Let me just say before we begin here, I'm hopeful that the board is going to review the background paper of the committee very closely. In many instances, the report is an indictment of the failures of the board and what needs to be done in order to make the board function more effectively. And I know that's the intent and your desire as well. So we're going to be hearing from several groups that also have serious problems with the board, issues that need to be addressed, and I know that you'll be listening carefully and working closely with all of us as we seek to achieve the level of support that's so important. And so with that, let me ask for your presentation.
Thank you very much. Good morning, Chairman Price, Chairman Gordon, and members of the committee. My name is Kimberley Kirchmier, and I'm the Deputy Director of the Medical Board of California. It is my privilege to introduce President of the Medical Board, Dr. Sharon Levine, who will provide an overview of the board and respond to the issues that have been identified by the committee.
Good morning, Chairman Price and Chairman Gordon. My name is Dr. Sharon Levine, and I'm here today as President of the Medical Board of California. I want to thank you all for providing this opportunity for the board to work with the legislature and the member of the two committees to review the body of law that governs the practice of medicine and the operations of the medical board. The Medical Board of California is an active consumer protection agency which licenses and regulates physicians and surgeons and those allied health professionals in California who fall under our statutory mandate. There are currently 132,000 physicians and surgeon licensees who are licensed by the Medical Board, and approximately 102,000 licensees who actually practice medicine within the state. The board's primary mission is consumer protection, and in addition, the board has an important role in helping to ensure that California remains a professionally attractive destination where excellent physicians want to practice. By statute, the board is authorized for 15 board members, 8 physician members and 7 public members. 13 of the board members are appointed by the governor and 2 by the legislature, 1 by the Senate Rules Committee and 1 by the Speaker of the Assembly. Existing law, B&P Code Section 2007, requires that 4 of the 8 physician members hold faculty appointments in a clinical department of an approved medical school in the state, but no more than 4 of these members may hold full-time appointments to the faculties of the medical schools. The board currently has 4 vacancies of our 15 positions, 3 public member vacancies, and 1 physician vacancy. Okay, so you're doing everything now. The board's budget for fiscal year 2013-2014 is approximately $56 million. Of that budget, 75% is spent on enforcement, which includes complaint handling, investigation, and prosecution. 10% is spent on licensing functions, and the remainder on administrative functions and probation monitoring. If the board spends its full budget in this fiscal year, it will have 4 months of reserve, and our statutory requirement is to have between 2 and 4 months of expenditures in reserve. It has been 7 years since the board appeared before the legislature for sunset review of the authorizing legislation and the body of law under which the board operates. And there have been a number of significant changes which have occurred since the last sunset report in 2005. In January 2006, the board implemented what was then a pilot vertical enforcement prosecution model, the result of a recommendation from the Medical Board Enforcement Monitor. The monitor's report recommended that in order to streamline the investigation, enforcement, and prosecution process, the Health Quality Enforcement section of the Attorney General's office hire or employ investigators to institute vertical prosecution. The law, which was finally passed by the legislature, actually retained the investigators within the Medical Board of California and defined a process whereby the Deputy Attorneys General would work in tandem rather than in a sequential model with the board investigators to investigate and prosecute complaints received by the board. In 2008, we saw a significant reorganization of the structure, membership, and functioning of the board. Prior to 2008, the board was made up of two divisions, the Division of Licensing and the Division of Medical Quality, which handled enforcement and disciplinary issues, and was comprised of 21 board members, divided between the two divisions. Board members in each of those two divisions were knowledgeable about the laws, regulations, and policy relating to their specific division, either licensing or enforcement and discipline, but were not well versed in issues not within the division. The board and staff at that time felt that consumers would be better served more effectively and efficiently if the two divisions were consolidated and the board size reduced to 15 members. And legislation was passed effective January 1, 2008 to accomplish this. That same bill made changes to the structure of the board, also provided the authority for the executive director of the board to adopt default decisions and stipulated decisions for surrender of licensure, which created an expedited process for these decisions and freed up time that otherwise was spent by board members in decision making. An additional significant change for the board was the termination of the board's diversion program. The board's diversion program, a monitoring program for substance-abusing physicians and physicians who are otherwise impaired. Under the diversion program, physicians who were found to have a substance abuse problem or an impairment issue were offered an opportunity to enter the program, where they were monitored for compliance with treatment agreements. If the physician successfully completed the program, there was no record of disciplinary action. Today, in the absence of the diversion program, whenever an individual is identified with a substance abuse problem, the board pursues disciplinary action against the licensee and seeks, as part of the disciplinary agreement, terms and conditions which include things like submitting to biological fluid testing, random biological fluid testing on a regular basis throughout the course of probation. Physicians must now, on their own, identify a program or programs that will assist them in maintaining and demonstrating abstinence for the duration of their probation and often beyond. The board has also made significant changes to ensure transparency and expedite public notice regarding board actions. The board has developed a subscribers list and allows any individual to go to the board's website and sign up to receive regular information feeds from the board via an email alert. And these alerts include things like disciplinary actions taken against a physician, new proposed regulations, the release of the board's newsletter, or notification of an upcoming meeting. The board now also posts all board agendas and meeting materials online, allowing the public to review the entire board packet prior to the meeting. The board, for the last 2 years, has been webcasting its meetings whenever possible. And in fact, some of our committee meetings are also being webcast. And those webcasts remain available for viewing on the board's website. The board has developed an application tracking system, again for efficiency purposes, that allows any applicant to log onto the board's secure website and view the status of his or her application in progress. This has decreased tremendously the number of phone calls to the board and to board staff asking what's happening with my application. The board also revamped and improved the lookup function on its website public disclosure screen. Members of the public can now verify that a physician's license is renewed and current, see any disciplinary action or other actions such as a conviction, malpractice, judgment award, other state discipline, etc. View the information physicians voluntarily provide in their physician survey upon renewal, such as ethnicity, foreign language skills, board certification, etc. And again, view any disciplinary documentation based on board actions. The board established a unit solely devoted to the unlicensed practice of medicine called Operation Safe Medicine in Southern California. The investigators within this unit are specially trained in undercover operations and have taken a proactive role in finding unlicensed individuals who are engaging in the practice of medicine.
I'm sorry, when was that task force established?
It was established in 2011. The unit has conducted arrests, filed a number of cases with the district attorney's office, and has made a substantial contribution to public protection. Its efforts have helped to increase the number of cases referred for criminal action by 203% from fiscal year 2006-7 to fiscal year 11-12. The unit actively works with other law enforcement agencies at the local, state, and federal levels. In April 2010, the board appointed a new executive director since our last sunset review. Under her leadership, significant improvements have been made to all areas of the board, and most notably, perhaps, with the board's licensing program, where review time for an initial application went from approximately 120 days to the current average of 30 to 40 days. Again, this is a critical issue in terms of processing applications and meeting the need for physicians to practice in the state of California. Most recently, at the end of February 21st and 22nd in San Francisco, the Medical Board co-sponsored with the Board of Pharmacy a joint forum on promoting appropriate prescribing and dispensing. The forum was attended by 400 individuals, primarily prescribers and dispensers of prescription drugs, and offered continuing education for physicians and pharmacists with outstanding educational content in the sessions. The forum focused on a comprehensive discussion of the dimensions of the epidemic of prescription drug misuse and abuse in the U.S. and in California, its sources, and the roles that prescribers, dispensers, patients, regulators, and law enforcement can and need to play in devising and implementing effective solutions. We were honored to have speakers from the White House Office of National Drug Control Policy and the Drug Enforcement Administration. Other speakers provided a physician's, a pharmacist's, and a prosecutor's perspective on the issue of prescription drug abuse, as well as a presentation on the cures system. At the conclusion of the second day, we heard from attendees on possible steps that could be taken to help address the issues, including educating physicians and pharmacists and consumers, funding cures, encouraging proper take-back programs, and much more accessible and frequent take-back programs of unused prescription medications and removing them from potential abuse or misuse, and exploring potential enforcement enhancements. The board videotaped the forum, and it will be on the board's website for individuals to view either in whole or in part for future reference. The medical board's goals for the future are to continue to enhance the efficiency of operations of the board and the staff, to reduce processing times both for licensing and enforcement, the core functions of the board, and to look for additional ways to make the board's work relevant and meaningful to consumers and to the profession. I want to now address the specific issues that were raised in the background paper. Issue number 9, vertical enforcement. In 2005, SB 231 established the Vertical Enforcement Pilot Program. Under BE, as I've described, board investigators are paired with prosecutors from the Attorney General's Health Quality Enforcement Section, the HQES, from initial assignment of cases for investigation all through the final prosecution of the case. The board believes that this pilot has demonstrated value and, in fact, is not a pilot any longer, and does not believe the legislature should revisit the original proposal to move the board investigators to the Department of Justice. The board submitted a supplemental report to the committee on March 4th, which includes a review of pertinent data from the VE program. We believe that the benefits of VE are real and do not believe that legislative changes are necessary at this time. We recognize that there have been challenges in the implementation of VE, in particular the initial efforts at developing a sustainable collaborative relationship between the Department of Justice and the Medical Board investigators. But those challenges can be addressed through continued and meaningful collaboration and joint problem solving between the board and the HQES, with resulting revisions to the procedural manuals and increasing consistency about the way the program is implemented in every one of the district offices. Areas that the board and HQES are committed to working on include establishing best practices and identifying areas where improvements are possible. The board will meet with HQES to resolve issues which arise and will formalize the resolutions in the manual. In addition to the quarterly supervisor meetings, quarterly meetings with the board and HQES management have been scheduled. A subcommittee of the board will be established also in order to track progress and identify needed amendments or enhancements to the process and to the workflow. In order to reduce the DAG's workload so they may devote resources to the highest priority concerns, the board is recommending that criminal conviction cases that do not involve quality of care require DAG involvement when the matter is ready for the filing of an accusation. This will enable the DAGs to focus on the highest priority matters from the perspective of public safety, such as interim suspension orders, enforcement subpoenas, and preparing expert reviewers for hearing, a critical piece in order for the board to be successful in its seeking of discipline. Interim suspension orders are essential to consumer protection. These orders remove a physician from practice when there is an identifiable risk to the public if the physician continues in practice. DAG involvement early in the case means that they are knowledgeable about the case and facilitates their preparation of the documents necessary to petition the court for an interim suspension order and to obtain the order expeditiously. In 2011-2012, we sought 36 interim suspension orders and were granted 28 of the orders, approximately 85%. Subpoena enforcement actions for obtaining medical records and physician interviews, again, are critical for enforcement, as the board is unable to determine whether the actions are of concern until the medical records have been obtained and reviewed and the physician interviewed. In 2009, the board adopted a zero-tolerance policy for delays in medical record acquisition and physician interviews. The DAG's attention to the process of subpoena enforcement when there is an attempt to delay is essential, and freeing up the DAG's time currently spent on criminal conviction cases will reduce the time needed to process these subpoenas. The board, through its expert reviewer training program, has determined that expert reviewers need more time, communication, and preparation by the Deputy Attorney Generals prior to going to hearing. We are recommending that the DAG have the expert review the accusation prior to filing, and very importantly, that the DAG and the expert meet prior to the hearing. This will prepare the expert for the hearing and ensure the expert understands the hearing process and that this is a judicial process and not a medical consultation process. And understanding that is not intuitive to physicians who understand that they're being brought in to give medical advice, but that the rules of a judicial process are what prevail in that setting. The board appreciates the value of the VE model and is committed to continually improving it, consistent with the goal of meeting our mandate of consumer protection. We look forward to working with the committee, the Attorney General's office, and interested parties to identify further improvements that will enhance the collaboration between the board and the AG's office. I want to speak to the issue of investigators. The report called out that in fiscal year 2000-2001, the board had 113 sworn positions. 90 of those were investigator positions, 23 were supervising positions. In the current fiscal year, the board has 97 positions, 76 investigators, 21 supervisors. The ratio of investigator to licensee in 2000-2001 was 1 investigator to 1,214 licensees. Today, the ratio is 1 investigator to 1,664 licensees. The numbers are accurate, but they're somewhat misleading because in the interim there's been a change in methodology in terms of what is called what the work of the investigators is. In 2007-2008, in an effort to assist with the investigators' workload, the board reorganized the probation monitoring program. Prior to this time, the investigators were not only doing investigations, but they were monitoring physicians on probation. In 2007-2008, the board determined that the monitoring could be performed by investigator assistants and inspectors. all of the investigators who had been assigned to probation were transferred to the district offices to assist with the investigations of alleged misconduct by physicians. In 2000 and 2001, the numbers referenced in the background paper, the 90 investigators included those within the probation unit. I want to next address the CPEI positions, which I know are of great interest to committee members and to the chairs. And this is a bit of a story. The board originally received 22.5 CPI positions under the Consumer Protection Enforcement Initiative, effective fiscal year 2010-2011, as Director Brown described in detail. The board began the process of writing descriptions for non-sworn investigators and hiring an additional manager and one staff services analyst in the central complaint unit, leaving the board with 20.5 positions to fill. As outlined in the background paper, there were several factors that impeded the filling of these remaining positions. Because the board conducted investigations for the Osteopathic Medical Board and the Board of Psychology at the time, 2.5 of the CPI positions authorized for the medical board were to assist in those boards' investigations. At the time, those boards determined they would rather have the positions under their specific authority, and in fiscal year 2011-2012, those 2.5 positions were moved from the board's allocation and provided to the OMBC and Board of Psychology, leaving us with 18 CPEI positions. During fiscal year 2010-2011, the board, in addition to getting these positions, was simultaneously required to decrease positions due to a requested workforce cap drill. The board had not filled the positions, understanding that the workforce cap drill was in place, and awaiting notice of how many of those positions would be subject to the drill and how many it would lose. In June of 2011, the board learned it would lose 2.5 of the 18 positions, leaving 15.5 CPEI positions. At that time, we were also under a hiring freeze, requiring the board to request hiring freeze exemptions for any position it wanted to fill, whether those positions were replacement of vacancies, either existing or those that occurred, and the CPEI positions. The board set priorities in submitting freeze exemptions, and at the time, because we had several existing sworn investigator and medical consultant positions that were vacant, was determined that replacing those vacancies, which would also require exemptions, were of a higher priority because those positions were essential and had work already identified for them. Additionally, there were also several licensing positions that were vacant, and again, we're under great concern about the length of time of licensing, and we're trying very hard to decrease the time that it took to fully license a physician. The board determined that exemptions for the existing vacancies with an already identified pending workload were higher priority than the recruiting for and filling of new positions, and so those were the exemption requests submitted in 2011-2012. The hiring freeze was lifted in November of 2011, and the board again began discussion to fill the CPEI positions. But in early 2012, we were notified it would be required to eliminate 18.1 positions due to the 5% salary savings reduction. Rather than eliminating existing staff, the board used the 15.5 vacant CPEI positions and 2.6 other vacant positions to meet the required reduction in positions. Because of this, we no longer had the CPEI positions. We were notified in September of 2012, however, that we could reestablish those positions in the temporary help blanket, as long as we always maintain a 5% vacancy rate across the board to meet the required salary reduction level. The board identified a plan to reestablish 14.5 of those positions, and at the time were given direction that there was an opportunity potentially to reclassify those positions to best meet the needs of the board. The board determined that the need to address the loss of investigator positions in the district offices to meet the intent of CPI to lower enforcement timeframe in consumer protection was actually our highest priority, and those were sworn investigator positions. We submitted the paperwork to the Department of Consumer Affairs to fill 11 of those positions. The board has recently been notified by DCA that the CPI positions actually cannot be reclassified and can only be filled with non-sworn special investigators. And we're now working on a plan to rewrite the description, identify the functions that these non-sworn investigators can fill, and to reduce, again, to support the investigators in reducing enforcement timeframes. And that's the story of the CPEI positions. I want to move next to the LA Times articles on prescription drug abuse. As everyone in this room is well aware, recent articles published in the LA Times described cases in which multiple patients of a single physician died from prescription drug abuse. And we actually want to commend the LA Times for their work in raising the profile and visibility of this issue. And I think we are confident that the interest and attention in attending the joint summit that the Board of Pharmacy and Medical Board put on was in part stimulated by concerns among pharmacists and physicians about, I think, an issue that everyone underappreciated. In order for the Board to investigate and take action, it must receive information about inappropriate prescribing. A complaint must be filed. Complaints regarding prescription drug-related offenses can be somewhat difficult for the board to obtain. In many instances, patients who are receiving prescription drugs in a manner that is not within the standard of practice are not interested in bringing a complaint to the board. Some complaints regarding overprescribing come from anonymous tips, and the board, in order to investigate these, needs enough information to allow forwarding to the board's district office for investigation, as there is no patient to obtain records for or inadequate information to open an investigation. Family members may make a complaint to the board, and then the board either needs a patient release in order to obtain medical records or seek a subpoena for the medical records. And again, that requires evidence sufficient to convince a judge that a subpoena is warranted in this case. The board has included a proposal to require coroner reporting of prescription drug-related deaths in its sunset report, and the board would like to thank Senator Price for introducing SB 62, which will require deaths related to prescription drugs to be reported to the board. This bill will ensure the board is notified about prescribing practices which potentially pose a public health and public safety threat, and the board is eager to work with interested parties, including the coroners, to ensure a bill which provides better information to the medical board to begin investigating potentially problematic prescribing. There was a question in the background paper around the decrease in investigations. And there are several factors that have led to the decrease in the number of investigations reported, comparing 2001-2002 to the present. Pursuant to a suggestion from the Enforcement Monitor, the board changed the way it collected and reported data for investigations. From 2001 to 2003-2004, the board reported things like citations for a physician's failure to change his or her address as an investigation. Beginning in fiscal year 2004-2005, the board no longer counted and reported these as investigations, but separated them out in a separate category as citations. These were removed from the total number and resulted in a significant decrease in the number of investigations opened. In fiscal year 04-05, 1,443 investigations were opened, compared to 1,887 in the prior year, almost a 25% reduction purely due to the change in methodology. Another change implemented in 2003-2004 involved the board resolving some issues with cease and desist letters and with citations issued through the board's central complaint unit, rather than referring the case to the district office for investigation, focusing on those cases where there was sufficient substantive information to proceed through the central complaint unit without the necessity for field investigation in order to issue a cease and desist or to issue the citation. Finally, the board has seen a decrease in the number of complaints received, which is proportionate, interestingly, with the decrease in investigations. In fiscal year 2000-2001, the percentage of cases referred to the field for investigation compared to the total number of complaints received was 21%. In 03-04 and 04-05, when the board changed the way it collected data for complaints and investigations, the percentage was 23% and 19% respectively. In fiscal year 2011-2012, the percentage was 23%. Although the number of investigations appears to demonstrate a decrease of 46% from 01-02 to 2011-12, the percentage of cases going to the field based on complaints received has remained consistent over the past 12 years. I want to move on now to Issue 12, SB 100, Price, Chapter 645, Statutes of 2011. This legislation required the board to adopt regulations on or before January 1, 2013 on the appropriate level of physician availability needed within clinics or other settings in which laser or intense pulse light devices for elective cosmetic surgery are used. The board's Physician Supervisory Responsibilities Committee held two interested parties meetings to establish the regulations, one in April 2012 in Long Beach and in July 2012 in Sacramento. Board staff received feedback at both of these meetings and drafted regulatory language based on the discussions. And the regulatory language is as follows. Whenever an elective cosmetic procedure involving the use of a laser or intense pulse light device is performed by a licensed healthcare provider acting within the scope of his or her license, a physician with relevant training and expertise shall be immediately available to the provider. For the purposes of this section, immediately available means contactable by electronic or telephonic means without delay, interruptible, and able to furnish appropriate assistance and direction throughout the performance of the procedure, and to inform the patient of provisions for post-procedure care. And such provisions are contained in the licensed healthcare provider's standardized procedures or protocols. Public regulatory hearing was held on October 26, 2012, and the regulations were sent to the Office of Administrative Law on March 4th for their review. When the regulation is approved by OAL, it will be adopted and effective in the following 60 days. The board also voted to amend the statute to require that the regulations apply to all clinic settings, not only those using laser or intense pulse light devices for elective cosmetic surgery, and to have the board adopt regulations to establish the knowledge, training, and ability a physician must possess in order to supervise other healthcare providers. And the rationale for this desired legislation is provided in our Sunset Review report. I beg your apology, I'm recovering from bronchitis. SB 100 additionally requires the board to adopt standards it deems necessary for outpatient settings that offer in vitro fertilization, and also allows the board to adopt regulations, those that should be deemed necessary, to specify procedures that should be performed in an accredited setting for facilities or clinics that are outside the definition of an outpatient setting. The board has not yet adopted either regulation, but now that the physician supervisory regulations are complete in the final approval stages, we will move on to addressing these additional regulations. The board does not gather information on the different types of outpatient settings, and so we actually don't, at this time, have data on the number of outpatient settings providing in vitro fertilization. But this is something we hopefully will be able to collect in the future once the standards are adopted. SB 100 also requires outpatient settings to report adverse events under Health and Safety Code, Section 1279.1, to the California Department of Public Health. The Medical Board has met with CDPH several times on this issue, and CDPH is working on a memorandum of understanding so they can legally share these adverse event reports with the Board. The MOU has not been finalized, and as such, the Board has not received yet any adverse event reports from the California Department of Public Health. The Board will continue to work with CDPH on this issue and keep the committee apprised of its progress. Board staff met with the 4 agencies which accredit outpatient surgery settings to inform them of the requirements of SB 100, including adverse event reporting, and has asked them to notify the outpatient centers that they accredit. The Board is following up to determine if actually that communication and notification by the agencies has happened, and if not, the Board will notify the centers ourselves. The Board has provided information on SB 100 and its requirements to all our licensees, including those who work in outpatient settings, by its newsletter in January 2012. And lastly, pursuant to SB 100, the Board has created the Outpatient Surgery Setting Database, which can be accessed through the Board's website. A consumer can search by owner name or setting name to access pertinent information intended to provide the desired transparency and help consumers make informed decisions not only about the physician, but also about the setting in which the procedure is likely to occur. The Board realizes that this database is not yet a very user-friendly system and is committed to continuing to improve the database to make it more consumer-friendly and to make the searches easier. We are also working with the accrediting agencies to ensure that they are reporting the required data and that we are getting them in a timely manner and able to post them on the website. We've recently added a link to this outpatient setting database directly from the Board's homepage to the site in order to make it easier to find and to perform a search for the setting. Board members have a keen interest in understanding the process of accreditation and in learning what the differences are among the 4 in terms of their process, procedures, and criteria for accreditation. We have invited each of the 4 agencies to present at our next board meeting in April on their accreditation process, procedures, and requirements, and on what the state of their communication is with those they accredit. Issue 13 related to peer review bodies. And pursuant to B&P Code Section 805, certain peer review bodies must report to the Board actions pertaining to staff privileges, membership, or employment. In fiscal year 2011-2012, 114 reports were received pursuant to Section 805. The Board actually does not track the number of reports received pursuant to the individual subdivisions of 805, but in total 114 reports were received. There has been a decline in the number of 805 reports received. In 2008, pursuant to a requirement in law, the Board had an outside entity perform a comprehensive review of the peer review process. Most of the recommendations required legislation for implementation, and I'll describe some of those for you. SB 700, Negretti-McLeod, Chapter 505 in 2010, added Section 805.01 to expand the requirement for reporting to the Chief of Staff of a medical or professional staff, the Chief Executive Officer, Medical Director, or other administrator of a peer review body, and to file a report following a formal investigation within 15 days after a peer review final determination that specified acts may have occurred, including gross negligence, substance abuse, or excessive prescribing. The first report received was April 1, 2011, and to date there have been 25 reports received pursuant to Section 805.01 from the expanded number of mandated reporters. This bill also required the Board to post a fact sheet on the Board's website, which explains and provides information on 805 reporting, to help consumers understand the process and what 805 reporting means in terms of consumer protection. And that fact sheet is posted on the board's website. The board has notified licensees of new reporting requirements under 80501 in the newsletter and has had several articles about 805 reporting in its newsletter. The board also incorporates these requirements into outreach provided to every one of those groups who are required to report on a regular basis. There are multiple possible reasons for the observed decrease in 805 reporting. Increased scrutiny of and rigor in peer review may actually be enabling hospitals and medical staffs to find problems earlier and to provide physicians with remediation prior to an event occurring which would require an 805 report. The implementation of electronic health records and the resultant transparency of the clinical care provided in institutions with electronic health records, as well as the growing demand for measurement and reporting of quality and safety data by hospitals, have made early identification of problems much easier and, in fact, inevitable. The growth of the use of hospitalists in inpatient settings. These are specialists who provide inpatient care, and this is all they do for the most part. It has resulted in significant improvement in the quality and safety of care provided in hospitals over the last decade because the physicians who are taking care of patients in hospital are dedicating their full practice to the inpatient practice of medicine. The decline may also be due to hospitals failing to report. The board does not have jurisdiction over the hospitals and has no way of knowing to what extent each of these potential etiologies may be contributing to the decline in reports. CDPH and other hospital accrediting agencies have the authority to review hospital records and conduct inspections of hospitals. The board is recommending that existing law be amended to require state agencies and hospital accrediting agencies to send reportable peer review incidents found during the inspection of a facility to the board for investigation. The board has submitted language to committee staff on this issue. On the subject of fully implementing the uniform standards, the board does not anticipate any problems that apply to full implementation. The board adopted regulations in July of 2012 that covered most of the uniform standards, including the requirement for a cease practice order for an individual on probation who fails a random test for drugs or alcohol. Status on the implementation is on the Enforcement Committee's agenda for its April meeting in Los Angeles, and the committee will consider at that time the remaining standard, including the standard relating to frequency of drug testing, which is the one in which a difference of interpretation, I believe, has led to the difference between full compliance with the uniform standards and what the board has already done. Issue 16 regarding the disciplinary guidelines is a framework for determining appropriate penalty for charges filed against a physician. Business and Professions Code Section 2229 identifies that the protection of the public shall be the highest priority for the medical board, but also requires that whenever possible, the actions of the board should be calculated to aid in the rehabilitation of the licensee. While the disciplinary guidelines frame the recommended penalty, the facts of each individual case may support a deviation from the guidelines, either more rigid or rigorous or less than the guidelines recommend. Once the administrative action has been filed, existing law requires that a pre-hearing conference be held to explore settlement possibilities and prepare stipulations, as well as a mandatory settlement conference, in an attempt to resolve the case through a stipulated settlement before proceeding to an administrative hearing. The Deputy Attorney General responsible for prosecuting the board's case prepares a settlement recommendation that outlines the strengths and weaknesses of the board's case. The DAG will use the board's disciplinary guidelines to frame the recommended penalty based on what violations can be proven. The DAG negotiates to settle a case with a recommended penalty, but may ask the board representative for authority to either reduce the penalty based on evidentiary problems or, in some cases, enhance the penalty. This type of negotiation is similar to what happens in criminal cases. In the negotiations to settle a case, public protection is the first priority and must be weighed with the potential for rehabilitation of the physician. When making a decision on a stipulation, the board is provided not only the recommended stipulated decision, but the strengths and weaknesses of the case and weighs all factors in its determination. The settlement recommended to the board and stipulated to by the board must provide an appropriate level of public protection and again take rehabilitation potential into consideration. Settling cases by stipulation that are agreed to by both sides expedites the rehabilitation of the physician unless there's a revocation, and ensures consumer protection by rehabilitating the physician in a more expeditious manner. By entering into a stipulation, it puts the individual on probation or on restriction sooner, and the public is able to see the action taken by the board more timely than when the matter goes to hearing. Currently, approximately 70% of cases are settled by stipulation. The board does not believe at this time that any changes are needed in the way it approaches stipulated settlements, and again emphasizes that consumer protection is always the first consideration. And issue 19 in the committee's background paper states that there has been a low use of interim suspension orders. And I mentioned before that in the last fiscal year we sought 36 interim suspension orders and were successful 85% of the time. I also want to point out that in addition to the ISOs and temporary restraining orders, the board utilizes restrictions pursuant to Penal Code 23, which are issued as part of the criminal hearing process as a condition of bail. Restrictions are also imposed via stipulated agreement to not practice or a stipulated agreement to a restriction in practice. The board can also require a physician to cease practice if they comply with a term or condition of their probation. In 2001-2002, 42 of these suspensions and restrictions were issued, and this has remained fairly consistent over the years. For the last fiscal year, 2011-2012, again, a total of these suspensions and restrictions were issued. An ISO is considered extraordinary relief, and pursuant to the Government Code Section 11529, a high standard of proof must be met in order for an ISO to be granted. Since every case presents its own set of circumstances, it is difficult to generalize why an ISO is not currently in place for a licensee. Before an ISO can be requested, there are a number of steps that must be taken. Securing the medical records and reviewing them, obtaining patient consent, medical consultant review, etc., in order to prove that the licensee's continued practice presents an immediate danger to public health, safety, or welfare, which is the basis on which the ISO is granted. Once the investigation progresses and the AG's office reviews the case, the AG determines whether there is enough evidence to warrant requesting an ISO, which must be granted by an administrative law judge. Even after the ISO requested, the ALJ has the ability to determine that there is insufficient evidence and can deny the request. We are trying very hard to ensure that seeking an ISO will result in an ISO being granted. There is a 15-day time limit in existing law that says that once an accusation must be filed within 15 days after an ISO is granted, and a 30-day time limit between the accusation being filed and the hearing being set. This essentially means that the investigation must be ready to file the accusation and to proceed to hearing before the ISO is filed. At this time, the board has not identified or taken a position on any potential modifications or enhancements to existing statutes for interim suspension orders. The board is moving on to the prescription drug use, issue 22. The board is very supportive of SB 62, Senator Price's bill, which will require deaths related to prescription drug use to be reported to the board. We believe this bill will increase consumer protection and ensure the board is notified of high-risk prescribing patterns, which will prompt an investigation. It's imperative that we know about these cases so we can investigate and take action. In September of 2009, the Department of Justice launched the Cures Prescription Drug Monitoring Program, which is currently housed in the Department of Justice. California was actually the first state to implement a prescription drug monitoring program, paper-based, of all 50 states. In the 2009 Cures program was an attempt to automate and allow for electronic filing of information by pharmacies. Cures is a state database of dispensed prescription drugs that have a potential for misuse, abuse, and addiction. Cures provides for electronic transmission of specified prescription data to the DOJ by pharmacists in the state on a regular basis. Pre-registered users, including licensed healthcare prescribers eligible to prescribe and pharmacists authorized to dispense controlled substances, law enforcement and regulatory boards, including the medical board, access patient-specific controlled substance history through a secure website. Since the launch of Cures, the board has utilized these reports as a very valuable tool throughout the investigative process. As part of our intake or triage review of new complaints received in the Central Complaint Unit when there's an allegation of excessive or inappropriate prescribing, the prescriber history report is generated from Cures. The report provides the board with information on the quantity of prescriptions written by the physician, which are then referred to a medical expert for review. Medical expert reviews the report to determine whether the quantity of medication being prescribed is either appropriate or excessive, and a field initiation can be initiated as a result. The medical expert also helps focus on specific patients who may be receiving a concerning amount or combination of controlled substances, as these patients generally do not complain to the board. The board's Central Complaint Unit also utilizes Cures to evaluate complaints related to care being provided to specific patients when the complaint is made by a family and the patient refuses to provide an authorization for release of records. A patient activity report is generated to identify whether the patient's getting drugs from multiple prescribers or from multiple pharmacies. If it's deemed to be an issue, again, we would subpoena the medical records and authorization for release from all prescribers or providers caring for the patient. When a case alleging inappropriate prescribing is sent from the Central Complaint Unit to the field, the investigators utilize the Cures report for a variety of purposes. Typically, the investigator will run a report that lists all patients for whom a physician is prescribing. They will look for patients for signals of problems, such as patients who reside far away from the physician's office or from the pharmacy where the prescriptions are being filled. Patients using a variety of pharmacies to fill prescriptions do this to avoid detection by pharmacy personnel. Numerous people with the same surname receiving scheduled drugs from the same physician, and a combination of drugs being prescribed, as well as the age of the patient. Once a sampling of patients who fit an aberrant prescribing pattern is identified, the investigator then runs the patient Cures report to again learn all of the prescribers writing the scheduled drugs for the patient. Investigators thus acquire information about a determination about whether or not the prescribing is within or outside the standard of care. Investigators have also found the Cures report very important for cases alleging self-prescribing or physician impairment. The Cures report is run for individual physicians to determine, again, if they're receiving a concerning amount of prescriptions and from whom and how often. It's important to note that the Cures report does not stand alone as an investigative tool. It's a roadmap that leads the investigator to the evidence necessary for prosecution. The board also uses the data to monitor physicians placed on probation following disciplinary action. A common condition of probation ordered for inappropriate prescribing is a limit on or restriction from prescribing controlled substances that a physician can prescribe. For example, a physician may be prohibited from prescribing Schedule II or Schedule II and III drugs during the period of probation. The probation unit will generate a report from Cures showing the physician's prescribing history to ensure compliance with probation. And again, a patient activity report to ensure that physicians are not receiving or writing prescriptions in violation of their probation. Cures is a critical enforcement tool. The system needs a stable source of sufficient funding to enable it to be upgraded, to provide real-time, rapid turnaround for inquiries, and to build the capacity to enroll and handle inquiries from all prescribers in California. I know the committees are aware that there is a single individual in the Department of Justice, a heroic individual, Mr. Mike Small, who is maintaining the Cures database and who single-handedly is enrolling people who are applying and spending a fair amount of time. He estimates 3 hours a day helping those who are actually approved to use the system to navigate some of the antiquated means by which prescribers are kicked out of the system in the process of trying to make an inquiry. As valuable as this tool is, currently about 8% of physicians in California have registered to be users, and only 6% of pharmacists. And the waiting time for enrollment as a user can be substantial. We heard testimony at the forum from a physician who had applied in July of 2012 and who has still not been enrolled into the system. The board has been and continues to be very supportive of efforts to identify a stable funding source for Cures, and is eager to work with the interested parties to identify and reach agreement on a funding source that will enable Cures to function optimally, to allow broader use of it, and again, to make it stable. I want to thank both committees for allowing the board to respond to the questions that you've raised. The board appreciates this opportunity and looks forward to working with both committees and their staff on issues that have been identified for future consideration. The board is pleased that staff has recommended that the licensing and regulation of physicians and surgeons and allied health professions continue to be regulated by the board members of the Medical Board of California and be reviewed again once again in 4 years, and we are happy to answer any other questions you have.
Thank you for your testimony and for your commitment to the people of the state of California. I do have a couple of questions before we move to the panel. In terms of the issue 12 and the surgical clinic oversight, has the board adopted regulations for clinics that are outside the definition of outpatient settings currently?
No, we haven't. We've just completed the first set of regulations and are scheduled to begin the process for the next two set of regulations stipulated in SB 100.
And what steps is the board taking to update the outpatient settings database so that it's more user-friendly? That was a big issue that came up repeatedly.
Yes. Well, we're trying. We believe that a lot of this will be facilitated and made much easier after Breeze implementation. It is quite clunky. We've tried to help by putting a very visible link to the database on the homepage of the board's website. And there are multiple places throughout on different pages where you can actually find it. We've added categories to the A through Z listing so you can actually get to the database, for example, by looking under A for ambulatory. We know that there are continued improvements needed, and we will do the best we can with the IT system we have. But again, think that we also have critical information we need to add, which we don't have as yet, such as adverse event reporting. And one of the issues that, as I mentioned, that the board members have a high interest in is there are currently 4 separate accrediting agencies for these outpatient surgery centers and outpatient settings, and they all have different criteria, they all have different standards, and they all have different administrative procedures. And several board members have asked, and these are scheduled for April, that these agencies come and report to us so that we can see if these are differences that are of concern to us. and want to understand why there are different criteria for accreditation. And so we're hoping to resolve that in 2013.
Yeah, well, I'm sure the members of the committee share your concern about that, and also would encourage some uniformity in a way that makes it easier to compare apples and apples. On the issue of Issue 15, the adoption of uniform substance abuse standards, at the board's last enforcement committee meeting, there was a staff proposal that indicated that 8 of 16 uniform standards did not apply. In light of the requirement to implement all of the uniform standards, how does the board intend to revisit this?
So I'm going to start, and I'll let Ms. Kirchmier add to it. Some of the 16 standards relate to a diversion program, which we no longer have, or to an audit of the diversion program. And so writing regulations, the Office of Administrative Law would probably send them back with a question mark. So we believe that we are in compliance with all but one of the standards, which is the frequency of testing. And we're taking that up at the next enforcement committee hearing.
Okay. Members, any questions? Mr. Gordon?
I want to go back to a couple of things. One, on the Cures program, I want to be clear. You presently look at that database when a complaint is filed, so you're not mining the database to see whether there are issues or problems.
Right. Do you want to speak to this? The medical board currently is a complaint. The body of law that regulates the medical board is a complaint-driven process. So currently, we go to the Cures database when we receive a complaint, a suggestion of a complaint, an anonymous phone call, anything that relates to prescription, the prescribing of or dispensing of controlled substances. Is what leads the medical board to the Cures database. There are a number of upgrades. It isn't the issue of the database is sort of twofold. One is capacity. It currently just doesn't have the capacity to allow the vast majority of prescribers to use it. But it also needs some enhancements, and among the enhancements that we believe it needs is to make the data queryable in a way that, should we get statutory authority to do so, we would be able to query it.
Thank you. Secondly, in terms of the outpatient surgery centers, the use of 4 different accrediting agencies, has the board, one, ever considered a single agency to provide some consistency, or requesting that this function be transferred to another, to say the Department of Public Health or some other state agency?
I'm not sure it's really within our purview to say one agency versus 4, but we are concerned, as I mentioned, about consistency of approach to accrediting similarly situated environments, and are interested in pursuing whether or not we can, in fact, do. First of all, we need to understand what the differences are, and one of the agencies is the Joint Commission. There's I don't remember all the acronyms, but the Joint Commission is one, and then there are 3 agencies that are specific for accrediting these kinds of settings, and our interest is in understanding what the differences are and whether they're meaningful, because consumers expect and should have the same level of protection no matter who's accrediting the setting that they're getting outpatient surgery, and that is a clear belief of the board. And in terms of transferring it to, it's kind of beyond my.
We actually haven't looked at the issue of. We haven't actually looked at the issue of transferring it. When we get an application from one of these accrediting agencies, we ensure that they meet not only the statutes, but we also have specific regulations that they must meet. And when we review those, when they apply, that's what we're looking at, is to ensure that they meet the requirements set forth in both statute and regulation.
Okay.
And they're very clear.
And we don't regulate the settings. All we can do is regulate, as identified in the statute, the agencies that accredit.
Okay, thank you very much.
Senator Emerson.
Thank you, Senator Price. Thank you, Dr. Levine, for your testimony here today. I have several questions I'd like to ask you. Assembly Bill 487, which was on pain management and appropriate care and treatment for the terminally ill, required most California physicians to take a one-time 12-unit continuing ed course on pain management and the appropriate treatment of the terminally ill. At the time, the concern revolved around the possibility of inadequate or otherwise inappropriate pain management practices. It now appears that the pendulum has swung to the other side. Does the medical board have any outcome measurements of the coursework required at that time?
No, we don't. The statute required certification of attendance, and there were a number of an entire industry sprang up to meet that need. I went through the training that was mandated at a series of actually an in-person course, and you're correct that we are now trying to recover from the impact of the training that was provided. And the difficult thing, I think, for prescribers, quite honestly, is that that bill followed a very highly publicized case of prosecution of a physician for undertreatment of pain and led to the legislation. And at the time, the leading pain management specialists in the country, and they have since recanted very publicly within the last year and have done a mea culpa, look what we've created. Part of the content of those courses was that that physicians are not serving their patients because they're not using narcotics. At the time, there was a great concern about the addiction potential for drugs like Vicodin. And the statements were made regularly and repeatedly during the training that if the patient has real pain, you don't have to worry about addiction. It resulted in a number of things. I mean, as you said, the pendulum swung to the point where you were considered, you were fearful of being criticized for inadequate pain management. It led to things like standing orders in a hospital for Vicodin every 6 hours as needed for pain. It led to the prescribing of quantities of controlled substances. Someone would go to a dentist to have a tooth extraction, was given a prescription for 30 Vicodin. Well, the unused Schedule II and Schedule III drugs are a major source of diversion. They're a major source of teenagers getting the single most commonly cited site for a teenager to get a hold of controlled substances is their parents' medicine chest. Very hard to find a physician who's writing a prescription for 5 tablets, which is pretty much what you need after a tooth extraction, potentially, if you use it at all. And so a number of things happen downstream from that concern about undertreatment of pain. Undertreatment of pain is a significant consideration, and it is an important issue in medical care. But to date, there is very little evidence, medical evidence, to support the use of long-term opioids in non-cancer pain. And yet the vast majority of opioid prescribing is for non-cancer pain. And so we do have a physician workforce that we need to re-educate, and I think people are catching on pretty quickly to the fact that in many ways the physicians have been misled by people exhorting them and saying, don't worry about addiction. Your job is to treat the pain. Well, it's not the whole story.
Thank you for those comments. I agree. In light of the concerns about the emergence of prescription drug abuse, does the board have a view on whether it might be time for something similar to AB 487 regarding appropriate prescribing of narcotics and the identification and treatment of dependence or addiction in the current era.
You mean another bill mandating CME?
Continuing ed to educate providers not to give 30 years.
We haven't looked at that or discussed it.
Yeah.
Dr.
Yes.
Can I just add on that? You know, we've really looked at this now. We're just beginning to look at this whole issue, and we believe that the joint forum that we had is definitely a step in the right direction. As Dr. Levine said, we had 400 pharmacists and physicians at that. We're looking at definitely posting it on our website. Of course, the CE was an incentive for those individuals to attend, and we're hoping to do another one of those forums as well. Additionally, what we want to do is really take this back also and be putting very proactive articles in our newsletter to identify that this is an issue and trying to educate our physicians, and Pharmacy Board is going to do the same thing as well. And then lastly, I think it's really important that we really educate the physicians on the use of cures and their need to use it when they're identifying patients that come to them. So we're really looking very hard at definitely educating the physicians, and we also have guidelines for prescribing that are posted on our website, and maybe it's time to get those out to the physicians again as well.
Thank you. In 2008, we enacted e-pedigree law that by January 1, 2015, e-pedigree law in 2008, we enacted it's go in effect on January 1, 2015, and it will require virtually every individual drug brand, name, and generic to have a unit-level identification that will allow tracking and drug authentication for manufacturer and pharmacies in dispensing to physicians and for administration. In California, we pride ourselves of being on the leading edge here, since there are drug abuse deterrent technologies in existence. Where's our leadership on requiring those types of controls in California?
So things like non-crushable tablets, is that?
Yes, that would be one aspect.
Right. The issue of non-crushable tablets has been a complicated one because the manufacturer of OxyContin has really promoted the fact that they've developed this. It's only available in one dosage strength. And so it's not, it's not applicable to all dosage strengths. And so it has resulted, we learned this, I learned this at the summit, at the joint summit, that what's happened is physicians are being somewhat naive when a patient comes in and says, well, I think I want this dosage rather than that dosage. And there has been a change in the frequency in prescribing of specific dosages based on trying to avoid the non-crushable form. There is some controversy in the industry as to actually how non-crushable the non-crushable is, but I don't think anyone believes it's the solution.
And Dr. Emerson, just to add on to that, what we have done is probably over the last 6 months, I believe, we have begun meeting with the Board of Pharmacy. The Board of Pharmacy comes to our meetings. Their executive officer actually has been attending our meetings, and we're attending their meetings. So we can actually get together and do education on e-pedigree and those type of elements that are starting to come to the forefront, so we can be aware of them and pass the information then also on to our physicians as well.
All right, thank you. I have one final question. Along those same lines, when the board identifies a prescriber that has a dependency or addiction problem and is engaged in a diversion program, is that provider allowed to continue to practice, and is it possible to add terms and conditions for those persons to remain in practice?
The board doesn't have a diversion program anymore. So those physicians are now proceeding directly to discipline. What the diversion program provided was an opportunity to avoid discipline if you complied with all the terms and agreements. And when the board identifies a physician with a drug dependence or alcohol dependence, there are definitely terms and conditions which allow the physician to practice, but generally in a restricted fashion.
Thank you for that response. I appreciate that.
One other item, just to add on to that too, Dr. Emerson, is that we actually, in our disciplinary guidelines, for example, if an individual tests positive, we have stated in there that we can cause them within 3 days of notification to cease practice. So we've added those in so they're stopped practicing if they're testing positive.
Good. Mr. Mullen.
Thank you, Mr. Chair. Thank you, Dr. Levine, for your presentation. Just a quick question on the Cures database. You mentioned a litany of issues with the administration, the administering of that database. So funding is clearly one of those. Has the board identified a prospective source of funding to adequately address some of those concerns? What might those be?
Well, last year there was a group of interested parties that met to try and work out an agreement on that, and I believe the current legislation that Senator Price has introduced has listed a large number of potential sources of funding, and we haven't. I don't think we've had a chance to actually meet on the bill or meet with the senator on the bill. It's really, I think at this point, I think everyone agrees on the goal. It's just about who's going to contribute how much. Excuse me, and to be sure that this is sustainable, that it's this is a continued source of funding, because the truth is, 25 years ago, prescription drugs were a very small part of a practice of medicine. Today, they're a substantial part. And the ability to understand and track how drugs are used and for whom they're being prescribed every year is a more important source of information.
And one other thing, last year when the bill went through to fund Cures, the board actually supported the position of increasing licensing fees to support some of the funding. Obviously, we'd be looking at everyone that can prescribe and dispense, as well as possibly pharmaceutical companies in the public, but they had voted last year to support that.
So the board itself has gone on record?
Yes, they have.
Dr. Emerson. Hernandez, I'm sorry. Hernandez. Looking like.
I was going to say, I thought Dr. Emerson already asked some questions. I want to follow up again and spend some time on the Cures and the overprescribing of the controlled substances. And I understand, obviously, that the funding's a problem. Also, the number of providers that get on is a problem. And you made a comment that it's complaint-driven. Is it the responsibility of the board to have a complaint-driven process as opposed to seeking out those individuals that overprescribe for public safety? I understand that we have individuals that are, patients that are going to shop. They're going to go to different providers. They're going to go to different pharmacists. They're going to do whatever they can. That's very difficult, and that's going to be difficult to control. But what about the physicians that are purposely overprescribing and looking and seeking out these individuals? Is it not the responsibility of the board to seek out those individuals, and how do you do it?
We don't have statutory authority to do so.
So the question would be then, do you think it's appropriate to have some type of statutory authority to do that for patient protection?
I honestly can't answer that ahead of a policy discussion at the board about what that would look like.
Okay. A couple of other questions. I know you have some vacancies right now. There's, I believe, 4 of them. I don't believe a quorum problem is in hand, but and my understanding that a couple of your meetings that individuals have left that you haven't been able to pass things. Is that continuing to be a problem, and how are you going to be able to address that?
So a quorum is 8 board members. We currently have 11 board members. There was a point at one board meeting where we only had 8 board members. That was a very transitory situation, but it did mean that when someone had to leave the room, we suspended the board, the board meeting, because we can't conduct business without a quorum. We would love a full complement of board members.
All right, one final question. With regard to your allied health professions regulated by the medical board, is there any specific entities that you feel you don't need and would like to move on to other boards at all?
We're gonna
Actually,
Yeah, please.
In our original Sunset Review report that was done in November, we actually put in that the Registered Dispensing Optician Program, we've been in discussion with the Board of Optometry about possibly moving that. However, our board took a position that they're not sure that it fits within the medical board, but they're not sure due to some interested party input that it fits with the Board of Optometry either. And so the board actually recommended in the Sunset Review that this is something we would like to look at, and I believe the committee said that we would hold interested parties meetings to discuss this and determine if there was an appropriate place for that group.
Thank you.
Any other questions, members? Yes.
Thank you. A little bit off topic from what the other questions are. We're going to have several bills this year on scope of practice. And does the board, do you take a position on increasing the number of intermediate healthcare providers, such as physician assistants, nurse practitioners, nurse anesthetists? That was a tough one.
Anesthetists.
Anesthetists, thank you. And nurse midwives in an effort to meet California's growing demand for healthcare.
Our role is public protection and public safety, and I don't think it's within our purview to opine on that ahead of seeing specific legislation. And
last question on staffing again. Since the legislature approved the BCP, the budget charter provision for additional CPI non-sworn personnel, why hasn't the board tried to fill the positions with non-sworn investigators as intended by the legislature?
Well, we just heard on March 4th that what we had submitted as reclassified positions was no longer acceptable, so we will proceed very quickly to rewrite those role descriptions. We had been given guidance in the past that suggested reclassification based on the board's best assessment of its needs was possible. And so the guidance has changed, and we will resubmit because we agree that we can use all the help we can get.
All right. Well, I appreciate your testimony and appreciate the willingness to work with staff and the committee. Senator Yee has got another question.
Thank you very much, Mr. Chair. I look at this document, the committee document. There are 39 issues related to your particular body, and related to that, the professions under which you provide some supervision and authority over. It seems as if in the presentation you've had that we're looking at identifying a particular problem, or a problem is identified, brought to your attention, and then you seem to now need to then address them. What concerns me is that I don't hear from the testimony, and maybe it's because no one asked the question, but is there an overall plan as to how do you prevent these problems from occurring? Because if you don't have that overall plan, then I think for the next, 10, 15, 20 years, we're just going to have a problem, and then we're going to have to identify the problem, and then we're going to have to come up with a solution, and then it just goes on and on and on. It just seems that this is a noble profession, a helping profession. Everyone's interested in helping patients. And so what is the overall plan to ensure that we're not going to have these issues again and again and again, and have a body that's going to be able to address them, and not have issues within the body itself again and again and again? And I think that's a concern that I have.
It's a very good question, and the board completed in the fall of 2012 our strategic plan. And many of the issues that you're talking about, the board has thought very hard about and actually does have plans for, including physician health, the issue of physician health, the issue of maintenance of competence. Currently, there's an effort to move beyond the traditional 25 hours of continuing medical education and to ensure, for example, for physicians who are not board certified or who have let board certification lapse, that they're actually involved in continuous practice improvement. This work is just beginning nationally at the Federation of State Medical Boards, and we have been in discussion with and are tracking the pilot programs. They're just now beginning to look at that. For decades, maintenance of competence, the assumption was you got all the learning you needed when you graduated from medical school and finished your training, and that's given the pace of change in medical knowledge, new knowledge creation, that's clearly an outdated notion. And so there's a lot of effort looking from a quality of care and patient safety perspective is what additional means need to be put in place to ensure that physicians are participating in an ongoing way in improving the quality and efficiency of their practice. And a lot of that is outlined in our strategic plan. The testimony today was pretty much, we were responding to the issues that were raised of highest concern by the committee staff and asked to speak, but we'd be happy to go into greater detail about. We have concerns about how stressful the profession is, increasing demands on professionals, not just for education, and for being able to actually keep up with, again, exploding medical knowledge, but things that we know are in the best interest of patients and in the best interest of patient safety, such as electronic medical records, have a significant impact on how efficient a physician can be in their practice, and we're in a transition phase. We are very concerned. The Affordable Care Act, October 1, the exchange opens for business, and January 1, 2014, the Affordable Care Act provisions go into become operative for the first time. And we know that California needs to be a net creator and importer of professionals to address the needs of those who currently don't have access to care and are not using the services of professionals. And we have great concerns. Scope of practice issues are one, how quickly we can license physicians, and how attractive and sustainable the practice of medicine in California is. And these are all multi-year and important issues in terms of ensuring a capable, highly professional, and extremely qualified professional workforce to care for Californians. This enforcement, or this sunset report, is really about the body of law that currently regulates the medical practice, the practice of medicine, the Medical Practice Act. But we are very interested in, and have been for a number of years, in the issues of prevention and early detection and remediation of problems.
Senator Yee, can I just add one more thing too to that? And in looking at all of these items, when we were preparing for sunset, we went through and looked at what issues we have at the board that either prohibits us from public protection or items that we've looked at. And I just wanted to point out that I believe, and I may be inaccurate on the number, but I believe about 21 of the 39 issues that were brought forward in the background paper were ones that the board actually looked at themselves and tried to identify areas where we really need either legislative help or input from the members to assist us. So I did want to point out that we've taken a really good review of the medical board to try to find areas where we need assistance or where we do find that we need help in this area. So we did bring those issues before the committee.
You're right. Just follow up. I appreciate the comments, and I appreciate the willingness to stay on target to look at these overarching issues of how to ensure that the profession is going to move forward with the utmost concern for patients. There's a couple of thoughts. I think number one, as we are moving into this increased access, there are going to be even more demands, and that if right now you don't have sufficient control of how to ensure that the individuals who are providing services are going to do it with the utmost care, then you're taking on even more responsibility. So you've got to have the system in place so that you can handle that. And I would just say that that it's absolutely critical that you continue to work with the chair and his staff to help you figure out how you're going to maintain that sort of quality overall, so that you don't end up with just more and more of these issues. Because my concern is that as we open up the gate for more individuals to get health care, there are going to be other challenges. All of a sudden you're going to have to work with different types of populations that some physicians have never worked with. The language issue, cultural issues, on and on and on. So if you don't have that overall perspective as to how you're going to ensure patient safety across the board, then we're going to come back another year with just a more litany of issues and all that. So.
Yeah, and just one of the things that I think is quite hopeful and optimistic in terms of the future is that there are other things that are happening that are bringing to light areas that need attention. For example, public reporting of quality and safety data that is mandatory under the Affordable Care Act. The growing tendency within California for physicians to practice in groups with electronic health records, which means that more physicians are in what we call examined practices, where it isn't just about the notes you write yourself and put in your drawer. So there is much more peer oversight of the work that physicians are doing, and then the capturing of that data and public reporting of it. And I think over the next 5 years, we're going to see a tremendous amount of transparency and visibility about variation in practice, variation in outcomes, and variation itself is like a very powerful magnifying lens that says that's where you need to focus your attention. So I think in many ways there are many things that it isn't the board having to oversee the individual practices of 100,000 physicians. There are intermediary bodies and intermediary processes that I think are going to make it much easier for us to see where, in fact, we need to focus.
Thank you. Thank you, members, for your questions. Thank you, panel, for your responses, and for the board's response to questions that were raised in the briefing. Certainly, the whole issue of healthcare reform is critical on everyone's agenda, and the medical board is going to play a real unique role in implementing it here in California. And so making sure that we have competent professionals and that there is transparency in a way that provides comfort to consumers, I think is a goal that we all want to achieve, and look forward to working with you to make that happen. Thank you. Thank you for your testimony.